CJ.
Did I pronounce your name correctly?
Yes, that's correct,
All
CJ.
right. Are you well?
I'm sure I'll be all right.
No, just relax into it. We are
Thank you.
pussycats. We won't be hard on you.
Thank you.
You're an attorney, an admitted attorney, notary, and conveyancer.
That's correct, CJ.
Admitted as such in 2005.
Correct, CJ.
All right. You have 2 degrees, an LLB, three, an LLB honors from Forte,
Correct, CJ.
and an LLM in international trade law
That's
from
correct,
Stellenbosch.
Yes.
All right. When did you obtain these degrees?
The LLB one is 2001, and the LLM is 2002.
So by the time you started as a candidate attorney, you had your academic qualifications under your belt.
Yes, I started with my article soon after completing my LLM.
Yes. And you started at Cliff Decker and then went to Chidl Thompson and Haysom and then lectured for a bit. What did you teach?
I was teaching labor law. I taught labor law at the University of the Western Cape for a term, but over and above that, I also taught contract law from time to time as a guest lecturer there as well, UWC.
Right. But that was only for a brief stint?
Yes.
Okay. And you then became director at Norton Rose Fulbright and then decided to take the leap and establish your own firm.
That is so, CJ.
When was that?
I left Norton Rose Fulbright in June 2023, and I started my own firm in July 2023.
All right. How is it going? Have you regretted that decision?
No, not at all.
On your own?
Not at all, CJ. I was wondering why I didn't do it sooner. I've been blessed in the sense that there are clients that know me from way back that have just continued to support me. So, yeah, and they were sad, obviously, to hear that I'm thinking of taking this step.
Yeah. What kind of work does your firm do?
It's mostly labor law, CJ, but before I started my firm when I was at Chidl's and at Norton Rose, I also do a bit of procurement law.
All right. When did you start acting as a judge, and in which court was this?
CJ, I've been acting since 2015.
At the labor court?
Yes, at the labor court. I've only acted in the labor court. I've not acted in any other court. So 2015, and then I think 2021 was the next stint, and then 2023 and 2024. So last year, I acted for 3 consecutive terms.
So how long in all have these stints, what do they total up to?
About 30 weeks. I see 2 of the law bodies did their calculations, and they say 30 weeks, and I'm happy to go with that, or 8 months, if you can, yes.
Did you get an opportunity to write judgments during these acting stints?
I've written so many, CJ. As I was preparing for this interview, I thought, how do I go through the 40 or so judgments that I've written to remind myself? But yes, I've written quite a number of judgments.
Any of them reported?
There are 2 that I'm aware, CJ, that are reported.
Okay.
Yes.
Right. Any taken on appeal successfully?
Yes, so there are 2 judgments that I did. I think the one I did in 2023 regarding prescription of awards, that was taken on appeal, and the appeal was dismissed. But I have to say it was dismissed on a different point than the one that I had decided. I had dismissed the contempt application on the grounds that the arbitration award had already prescribed. But when the matter went to the LAC, the court took the view that because the employee failed to tender services after the award had been issued, that issue was dispositive of the appeal. So that appeal failed, but as I said, it was decided on a different point. Then the other judgment that I wrote, which was taken on appeal, relates to a Section 197 transfer of a business. I think last month the LAC overturned me, unfortunately.
One of the professional bodies, I think it's the GSCB, complains that you did not disclose the details of these judgments, so they were not able to review them. So we have to take your word for...
I saw that, CJ, and I immediately regretted it that I had not mentioned the details. Why I did not do so at the time, I can't explain now, but yes, it would have been of assistance to the law bodies to know about the judgments that I had written, which had been taken on appeal.
You listed 8 reserve judgments in your questionnaire. Have these been delivered?
Yes, CJ.
All of them?
I am pleased to report that all of them were delivered within the 3-month period, except for one judgment which I rendered last week, but it's because the record was quite voluminous. I was sitting with 7 or 8 lever arch files in a review, so it took me a while to get to the judgment, but yes, that went out last week.
How long did it take you to deliver this judgment from the time of the hearing?
The hearing was on the 21st of November 2023, and I handed down the judgment last week, the 28th of March 2025. So that's I think, just over 4 months on my calculations.
Sorry, when was the matter heard?
21 November 2024.
Not 23?
No, not 2023.
Okay.
Sorry, CJ.
Okay.
If I said 2023, it's an error. Yeah.
No, it's within time. Do you deliver your judgments timelessly?
I believe I do, CJ.
Well,
Often
there are norms and standards. Are you able to deliver them within the prescribed 3-month period?
Yes, CJ. So let me put it to you this way. Obviously, when I started back in 2015, judgments were not going out promptly. And when I joined the system, I just played along and handed down judgments as and when I could. But obviously, since 2023 and 2024, and knowing that the requirement is that judgments must be handed down sooner rather than later, I've tried to make sure that all my judgments go out within at least 3 months. Sometimes I'm even able to render judgments overnight, and sometimes I'm even able to do extempore judgments.
All right. Thank you, Ms. Gandidze. Judge President Mulahle, first welcome. I forgot to do that when we started. I guess I was a bit cross with the gentleman who's late, one of the gentlemen sitting next to you from Netleg. So you can blame my lack of courtesy on him. And welcome to the Netleg members as well. It is your turn to put questions to the candidate if you have any.
Thank you very much, Chief Justice, and good morning, all the commissioners. Good morning, Ms. Gandidze.
Good morning, JP.
Are you okay?
I'm all right.
We can't hear you, JP. Would you?
Can you hear me?
I can now.
Oh, okay, my apologies. Chief Justice has touched on most of the questions I would have liked to put to you, particularly around the kind of work that you do. I see from your papers you do about 80% of your practice is labor law.
Indeed, JP.
Now, before we go into the details, you've applied for the position in Cape Town.
I've indicated that Cape Town is first choice because I'm obviously based in Cape Town. So,
Okay.
that would be first choice. But if Cape Town is not an option, then I'm prepared to be considered for a position in the Johannesburg court.
Okay, because there are 3 positions that have been advertised, 1 in Cape Town, 2 in Johannesburg. So you would be willing, if you are successful and it's so decided to make your main seat in Johannesburg, to consider that?
Indeed,
Okay,
JP.
thank you very much. And that would entail, as you're aware, the appointment in the labor court, you're not necessarily appointed to one court per se. You travel around.
Indeed.
Generally, you travel 2 weeks per term, but that's not a fixed rule. That depends also on the workload. Now, during your acting stint, how did you find the environment in the labor court?
JP, if you can just be a bit more specific, environment in terms of the kind of the work?
In terms of your engagement with the other judges,
Oh, okay.
attending tea.
Yes.
You may have seen in the acting judges manual, we
Yes.
do emphasize attending tea, and somebody who reads it may think, these people want to go to tea. So
Yes.
how do you find, what's the value of that?
No, there is great value, JP, in going to tea, because my experience has been that we talked about the cases that we were doing, and I remember many years back that, especially us as acting judges, we were encouraged to attend tea, because that is the opportunity that you have to speak to permanent judges.
Sorry, my apologies. Apologies, Chief Justice.
Yes, no, that's
go
all
ahead.
right. To speak to permanent judges and other judges about whatever matters that you might be working on. But it's also an opportunity to know your colleagues. In fact, I think it's the only opportunity to know your colleagues, because you arrive in the morning, you're busy with your files, and you go to court. You're busy writing judgments during the day. So tea time is the opportunity that you have to mingle with your colleagues. So I found that very, very useful.
Yes. And I looked at the recent acting stint. You acted between 14 August to 15 September. You acted again 1305, 2024, sorry, and 2023 to 2106, 2024. And again, you acted 2608 to 2009, 2024. I looked at some of your judgment. You seem to have delivered them all within the required time. And you've also mentioned earlier that you've picked up in terms of ensuring compliance with the protocols.
Indeed.
And how did you manage to get to that?
JP, there is no other way to say this. It's just a lot of work. You work most of the time, but unfortunately working hard comes easy for me. I don't mind. I would rather sit there and be working than sit around and do nothing. But I also have to say that in the time that I've been acting, I've interacted with permanent judges who have specifically mentored me and said to me, you need to pick one day a week where you take a break, whether it's the Saturday or the Sunday, and I've tried to apply that, but most of the time you are working all the time, unfortunately.
Okay. I take it during your acting stint, you've covered most of the spectrum of the cases that are handled in the labor court, particularly your urgent court and your unopposed motion. Those are the most challenging courts.
Yes, indeed. I've done that, JP.
You have done that.
Yes.
And the urgent court, did you do it under the new system of the court online?
Yes, JP, I did that when I was on duty in Cape Town. Remember, when you are in Cape Town, if you're on duty doing motion court, then you are also responsible for doing urgent applications. So yes, I think I had 1 or 2 urgent applications that were brought in through the new system. And when I was in Port Elizabeth, no, I didn't have any urgent
Port
applications.
Elizabeth was still
yeah.
lagging behind. It
Yeah.
was just catching up in as far as that is concerned.
Yeah.
But how did you find that the use of the new system? Is it helpful? Is it causing delays? Is it putting more pressure on the judges?
I think it's definitely helpful for the judges, because you have everything on your laptop. You carry your laptop with you everywhere you go, and so you are able to refer back to the documents that the parties were relying upon without having, to lug around with a big suitcase. But in my experience, I think the attorneys are still struggling. We've had cases where the people would come to the registrar and say, really, I'm here, and I've got the hard copies of the documents, and the judge is here. Can't you just give the judge the documents? So I've noticed that's creating a problem. It's creating a problem for attorneys, but it's also creating a much bigger problem for unrepresented litigants.
Okay. I can assure you that problem, particularly in Cape Town, has now been addressed by the Technical ICT Committee.
All right.
And have you done any case or virtually?
Yes, yes. In fact, the one trial that I did in Joburg, I think the beginning of November, we didn't finish it the Friday, and the following week I was scheduled to be in Cape Town doing motion court. And because Monday is a reading day, I then opted to continue with the trial on a virtual platform from Cape Town because the representatives are here in Johannesburg. So yes, I have.
Okay, I'm pleased to hear that because in Johannesburg now, we've set up a proper and fully fledged virtual court.
Okay.
You simply walk into that court and every screen and every screen is set up for you.
All right.
And we're looking forward to that. CJ, I think that's all I would want to ask.
Thank you, JP Mulahlehi. Commissioner Matolo Tlepu.
Thank you, CJ. Good morning, Ms. Gandidze.
Morning, Commissioner.
Okay, I'm just interested, with issues of transformation and empowerment. I see you have done your LLM in international trade law.
Indeed.
And in 2002, have you ever had an opportunity really to practice in that? Or do you ever get that opportunity to practice in that?
No, unfortunately not, Commissioner. And as I indicated in my questionnaire, I think, in my 20 years of experience, there are only two matters that I got involved in where international trade laws were implicated. But other than that, I've not been involved in, I can't say I'm practicing in international trade law, no.
But I'm just trying, why I'm curious is it because you never got an opportunity to practice in that type of law, or you never had a chance? Yeah.
Commissioner, I think when I finished my LLM, I went to Chidel, Thompson and Haysom, and they don't exactly have a department there that works on international trade law matters. So obviously you work with what you have. Yes, you work with what you have, and when I was at Norton Rose, I was in the Labor and Employment Law Department again. I don't know that they have a department dealing with international trade law. So yes, I think it's a case of I just haven't seen the opportunity to get involved in international trade law matters.
Thank you, CJ.
Thank you, Commissioner. Professor Marumachai.
Thank you very much, CJ. Good morning, Ms. Gandidze.
Good morning, Commissioner.
I want to ask you about something that I find very, very interesting, and I think you delivered a judgment on your bundle of documents.
Yes.
I'm not sure if the bundle that you have is paginated, but the one that I have is not. So it's page 32 of the bundle. It is a case of Forsman versus Mpeshu Property Investments Pty.
Yes.
Yes. I'm quite interested in this judgment because the world of labor or the world of work is changing so drastically that we find it difficult to know who is the employer, who is the employee, and to define the workplace itself. And in this matter, you are dealing with an issue at the gym and the person who's working there and trying to understand whether the person was an employee or the person was an independent contractor. If you go to paragraph 103 of that judgment.
Sorry, I beg your pardon, paragraph?
103.
103.
103 of the
Thank you.
judgment. You list various common law tests that were there to determine who is the employee. And then immediately after dealing with that, you go into the submissions of the parties. What I want to understand is, because before you deal with the various tests, you actually provide the statutory presumption that assists us to determine who the employee is.
Yes.
And when I read the judgment, I'm not quite sure whether, because ultimately you find that the person here was an independent contractor as opposed to an employee, and thus the court will not have jurisdiction for obvious reasons.
Yes.
What I'm struggling to understand is, I'm not really sure for you to reach that determination or that conclusion, you applied the common law tests or you applied the section 200A of the LRA, in other words, the rebuttable presumption provision. I'm not sure if you would recall, but when the court determines who the employee is, what is the actual test that is applicable? Are you looking at the statutory test, or are you looking at the common law test? In other words, is the common law still relevant in determining who the employee is, given how those 7 factors that determine who the employee is are actually structured in the Act?
Yeah. Thank you, Commissioner. So to answer your question, the approach that I took is one where I took into account Section 200A of the Labor Relations Act, and then I also considered what the Code of Good Practice on who is an employee is, and then I also look at case authorities, and as you rightly pointed out, what you refer to as the common law is what's dealt with in the case authorities, where I said, even though the dominant impression test has received heavy criticism, ultimately the courts, they've accepted that that is the test that you ought to take into account. In other words, you look at the totality of the circumstances and you apply everything. You apply what's in Section 200A of the Act, you apply what's in the Code of Good Practice, as well as the common law test to say, taking into account everything, do you say this person was an employee or an independent contractor? And after applying all of that, I came to the conclusion that, in fact, the person was an independent contractor as opposed to an employee.
Can I follow up, CJ? I guess my question is not necessarily to that effect. What I'm asking is, when you look at Section 200A and the 6 or 7 factors that have been outlined there, they take into account the control test,
yes,
the dominant impression test, and the organization test. So when you look at how they have been structured, they codify the common law. So what I'm asking you is it still necessary for the court, when determining who the employee is, to refer to the common law test? In other words, is there any value still to deal with the common law, while the statute actually gives you a rebuttable presumption as to who the employee is?
Yes, I hear you, Commissioner. I guess the problem with what's in the Code of Good Practice and what's in the Act is that it just gives you factors that you need to take into account. And where the common law comes in my respectful view, is that the common law tells us that take into account all of that. It's not a tick box exercise where you say, because I've ticked A, then this person is definitely an employee. I've ticked B, the person is definitely an employee. The common law test requires us to look at the totality of the circumstances and say, taking into account everything. So to answer your question, yes, definitely the common law is still very much relevant, and I think it still needs to be applied when you are determining whether a person is an employee or an independent contractor.
Thank you very much, CJ.
All right. Chairperson Sonitipan.
Good morning, Ms. Gandidze.
Morning, Commissioner.
I must say, Ms. Gandidze, your journey is an inspiration to many young women out there. At the age of 46 years, you've already attained so much for yourself. Now, please briefly tell us, who is Ms. Tapiwa Cecilia Gandidze, starting from your childhood ages?
Starting from my childhood age, so I was born in Zimbabwe. I grew up in Zimbabwe in a village, and then went to boarding school for my high school, and then went to Fort Hare University tertiary education in 1998. I don't know whether that covers what you want me to cover in your question, but in a nutshell, I come from very humble upbringing, and I've heard to work my way up to be where I am today. I don't know if that answers the question.
No, I think I'm happy with your response.
Thank you.
At least we do have the gist now.
Thank
Who
you.
are you? Now, my next question will then be, by its nature, the labor disputes are adversarial, but alternative dispute resolutions mechanism like the mediation and arbitration, they do play a crucial role in the labor law. How do you see the role of the labor court judge in promoting effective dispute resolution beyond litigations?
Yes, I do think that as labor court judges, we definitely do have a role to play, and I will speak from experience. I've heard files before me, and I go through the files, and I go through the issues, and I then say to the parties, it seems to me that the real issue is actually issue X, and it seems to me that if the parties can go down the passage and have a conversation about it, you're actually able to resolve the matter. And in my experience, that has actually worked. Parties come back to me and say, you know, thank you, Judge. We've actually had a discussion about what you proposed, and we've resolved the matter. Mediation, I know it's not provided for in the Act, as I can recall. I think that's a function that's offered by the CCMA. But I do know from many years back when I was involved in some strike-related disputes that we would appear before a judge in the labor court, and the judge would propose that you know, the parties explore mediation before resorting to litigation, and it worked in some of those cases. So I think mediation definitely has a role to play in resolving labor disputes.
Okay. No, thank you very much, CJ. No follow-up.
Thank you, Commissioner. You mentioned that you were born in Zimbabwe, and just to make sure that we comply with the Constitution, which requires judges to be South African citizens. You are a South African citizen.
I am a South African citizen, CJ.
Yeah, I thought so.
Yes, I am.
When did you acquire that citizenship?
2016, 2017, somewhere thereabout.
All right. Thank you, Ms. Gandidze.
Thank you.
President Mulemela.
Thank you, CJ. Good morning, Ms. Gandidze.
Good morning, President.
Have you ever been in a situation where you were involved in a review application and discovered that the record was incomplete? And if that is the case, how did you deal with it?
Yes, President, I know that there was a time when the case authority suggested that if an applicant places or asks for a review application to be enrolled in circumstances where the record is incomplete, there was a time when the approach of the labor court used to be to just dismiss the matter. But I do know that with I think the practice manual from 2013, there were then provisions in the manual to the effect that if the record is incomplete, then the judge president can be approached for directions on how the matter must be dealt with. If it's possible to reconstruct the record, that's an option that can also be explored. But if the record is necessary for purposes of deciding the review and it cannot be reconstructed, then there are matters where matters that have been remitted to the CCMA or the Bargaining Council. So when you ask about my experience, I do know that I think last year, 2024, I had a matter before me where the record could not be reconstructed at all, and the issues that were raised in the review application required me to have regard to what was in the record, and I then remitted the matter back to the CCMA for a fresh hearing.
Oh, for a fresh hearing?
Yes.
Okay, thank you. Okay, sorry, CJ, just a follow-up. And what would you do if only part of the record is missing, not the entire record?
So, President, it depends on the issues on review. If it's an issue that you can decide based on the record that's before you, then I would decide the matter based on that record that is before the court. But if I'm not able to decide the grounds for review based on the record that's before court, then I would first prize ask the parties to see if they can reconstruct the record, and if that is not possible, then I will consider remitting the matter to the CCMA or the bargaining council. So the answer is it depends on the issue. There are some issues that you are able to decide on review without a record, but there are some issues where your decision has to be supported by what is in the record.
So if the record is incomplete and you are remitting to the CCMA or the bargaining council for reconstruction, would you give any directions to the CCMA or the bargaining council regarding the reconstruction? And if so, which directions would you give? Or sometimes they are referred to as directives.
Yes, so I would give a directive, but I think it's a directive that I would give in consultation with the parties, because they are the parties involved in the matter, and they know more about the matter than I do. So I would say to them, my sense is there is insufficient information for the review to be decided, and invite their submissions on the issues that, or the information or the evidence that's missing from the record that would need to be decided by the CCMA. So I'm saying my sense is I wouldn't give that directive on my own as the judge without consulting with the parties.
Thank you, Ms. Gandidze. Thank you, CJ.
Thank you.
Minister? Thank you very much, CJ. Good morning, Ms. Gandidze.
Good morning.
Just looking at your work that you have done and around the exercises that you've done, voluntary work that you've been able to do, and work around women. But more so for me will go in terms of the issues of access to justice. I hope I'm audible. Let me just bring it closer. The issues of access to justice. In looking at majority of the people, what they have as access is work in the CCMA level, and some of the people are not able to have access to labor court. What do you think should be done to ensure that labor court is more accessible to ordinary workers, and as part of making the whole system accessible to South Africans?
Yes. Thank you. My view is already the labor court is doing enough. I know of matters where I sit in court either as, a party representing a party, and an unrepresented litigant gets up in court and they try to address the court. And my experience is the judges have been very understanding and say to the unrepresented litigant, your papers are not in order, and if you are not able to afford the services of an attorney, I would recommend that you go to, there's the SARS law office that sits, I think I don't know about PE and Durban, but I definitely know they sit in the Joburg and the Cape Town Labour Court. Judges have referred matters to the SARS law office to make sure that people get assisted. There are some matters where you can assist as a judge, but obviously you need to be very careful what you do so that you're not seen to be assisting an unrepresented litigant. So if it's a matter where the legal issues are not properly set out in the papers and you can't assist with that as a judge, what I have done, I've also done it as a judge, is to refer the unrepresented litigants either to the SARS law office or to the legal aid clinic.
Just to follow up on the same matter, because you've now articulated on the unrepresented litigants. And in this regard, the issue is just broadly, and perhaps my issue is broadly around whether you look in terms of the physical presence of where the courts are, the issues of understanding and being, if I'm a litigant, I'm unrepresented, as you say, I might not be able to represent myself because I would not understand how I should be able to write my affidavit and all that. but more so as well the cost associated with it as we look at what the Legal Aid Board is able to offer. A low-income earner who earns below 8,000 currently will not be, or who earns above 8,000 will not be able to get represented, and therefore the above and the category and the affordability. And I want to understand from your view, in terms of having worked with communities, having worked with the most vulnerable, what's your view generally around where we're sitting as a country in terms of access to justice to the most vulnerable of our communities?
Yes. Thank you, Commissioner. Yes, that's definitely still a challenge, and I wish we could do more, but we work with what we have. I want to give you an example. I think last year I had a review application involving an unrepresented litigant who is based in George, and it was a review application, and I received an email that he was requesting that we have the review on a virtual platform as he's unable to travel from George to Cape Town. And obviously I didn't even think twice about it. I just thought that's what we do. But unfortunately, the case involved a review application where there was no review record. There was absolutely nothing before the court, and the litigant stated that because he's unemployed, since he lost his job, he's unemployed, he's not been able to find a job so that he can have the record transcribed. And I understood the situation, but at the same time, I also felt that my hands are tied. If it's a review application and there is no record before the court, unfortunately, the court cannot assist. So you try and assist where you can as a sitting judge, but unfortunately, and demonstrated from the example that I've given, there are just some cases where your hands are tied, even as a judicial officer.
Commissioner Likhanyane?
CJ, thank you so much, and good morning, Ms. Gandidze.
Good morning, Commissioner.
Just one question. Where, for instance, the labor court finds that a hopeless case is being pursued, especially by those who are in the senior echelons of state administration, and that weighs very heavily on their juniors. And the court arrives at that determination. Do you think that it is justified that the court can order that the cost must be borne by those that pursued that hopeless case? Thank you.
Thank you, Commissioner. The answer is definitely, and especially where people are legally represented, and they still insist on having a matter litigated, which a court describes as hopeless. I've got no question, I've got no doubt in my mind that people must be penalized with court orders to discourage other litigants from pursuing hopeless cases.
Commissioner Hassan?
Thank you very much, CJ. My name is Commissioner Fasiya Hassan.
Thank you, Commissioner.
Thank you very much. I have a different question. In your papers, you spoke a lot about your extracurriculars and work outside of the legal fraternity, related to you being the chair of the Cape Town Rape Crisis Center, as well as mentoring a young black woman attorney. So I'm just interested if you could maybe expatiate on some of this work around gender empowerment and some of your activism work more broadly, and how it positively or negatively may affect your role as a potential judge in this particular labor court. Thank you.
Yes. Thank you for that question. I must say it's a question that I always anticipate when I sit in these matters. But I can assure you that I've probably written 3 or 4 judgments on sexual harassment matters. When I look at the matters and I write the judgments, I write the judgments based on what the facts tell me and what the law tells me. And I think of the 4 judgments that I have written, there's one involving the I think it's Home Affairs, where an employee was dismissed for sexual harassment, and I came in and I said, it's understandable why a commissioner would find that the employee was involved in sexual harassment, but taking into account the facts of the matter and the circumstances under which the conduct complained about had occurred, I was of the view that the employee could be given a final written warning and return to work. And obviously, when I wrote the judgment, I was very much alive to the fact that the department might not be happy about the conclusion that I had arrived at, because there's, in my view, a misunderstanding that every case involving sexual harassment must be met with a sanction of dismissal. And I expressed a view in that matter that is not so. You must always be guided by the facts of the matter that's before you. So yes, I am an activist, but at the same time, I know I'm a lawyer at heart. And when I sit in these matters deciding which way to go, I apply the law. And I leave my activism at the door, so to speak.
Commissioner Moiman?
Thank you, Chief Justice. Greetings to yourself and fellow commissioners and Ms. Gandidze.
Yes, thank you, Commissioner.
Thank you. Just one question from my side, which relates to one of the judgments that you referred us to, Mugwazi versus SAT.
Sorry, I beg your pardon, Commissioner.
Mugavazi versus South African Airways Technical.
Yes, that's in my pack, yes.
Yes, that is the case that I'm more interested in. 2 areas or objections that were raised by SAT. One on the two cause of action emanating from the same set of facts.
Yes.
One that Ms. Mugavazi filed an individual claim alleging unfair dismissal based on discrimination. Then the second one, the matter brought by her union, NUMSA, following Section 189A.
Yes.
Kindly just explain to me the distinction that you brought to make a pronouncement on those 2 objections that were raised by SAT.
Yes.
Thank you.
Thank you, Commissioner. The first one, as I recall it, was that, maybe let me just go to the facts, just so there is context. So a number of employees were dismissed following a Section 189 process, and NUMSA then referred a dispute to the Labour Court, seeking to challenge the dismissals. But what Ms. Mugavazi then did was she referred the dispute to the CCMA for conciliation, which is a box that must be ticked before the Labour Court can have jurisdiction in these matters. So at the Labour Court, the referral that was made by NUMSA was challenging the substantive and the procedural fairness of the dismissal, and had nothing to do with discrimination. And remember, I said that Ms. Mugavazi referred her dispute to the CCMA, and that matter was conciliated. And in those proceedings, she specifically raised the issue of discrimination. So when the matter came before me, the employer sought to argue that, in fact, this matter is already pending before this court. And I think at the time, the Labour Court had actually dismissed NUMSA's claim on whatever basis, I can't quite recall, and the matter was now with the Labour Appeal Court. So the approach that I took was to say, But the matter that Ms. Mugavazi has brought to court is one that relates to a discrimination. Obviously, she's also alleging substantive and procedural fairness, but she's also alleging discrimination, whereas the dispute that NUMSA had referred to the Labour Court did not involve a discrimination. So that was one of the issues. I can't remember the other issue. But yeah, that was the least pendants point that was taken by the employer, which I dismissed.
Thank you, Ms. Gandidze. Thank you, Chief Justice.
Commissioner Trolley?
Thank you, Chief Justice. Good morning, Ms. Gandidze.
Good morning, Commissioner.
In your description of your legal background, you mentioned the good fortune of being assigned to, during your clerkship, to work with the late Mr. Tim Mills.
Yes.
What motivated you to mention this, and what was the most beneficial experience of working with him?
Yes, so Mr. Mills is the director that I worked with when I was at Cliff Decker doing my articles, and I think the first 6 months I was allocated to him. It was, for me, just such a pleasure working with him. It wasn't just work, it was work and playing. He gave me opportunities to draft papers. He sent me to court with counsel. He sent me to consultations with clients, and I could see that he genuinely believed in my abilities to be able to do the task at hand. And obviously after the first 6 months, I then moved on to the other departments, but I wished I could go back to him. And I guess I can say maybe that's when my love for labor law developed, because I really enjoyed working with him. And I must say, when I was interviewed at CTH, they wanted to see if I was capable of drafting, if I drafted any heads, if I drafted any affidavits. And I just went back to the documents that I had drafted in the first 6 months of my articles with Mr. Tim Mills and presented those to them at Chiddles, and they were convinced that I was capable of doing the job of a labor attorney. So yeah, he left an impression on me, and yeah.
Thank you, Chief Justice. Thank you.
Commissioner Mangena?
Thank you, Chief Justice. Good morning.
Morning, Commissioner.
Good. I need to ask you a question regarding the matter of Payne versus Department of Education.
Yes.
You were dealing with a complaint arising out of unfair discrimination.
Yes.
Yeah. The referral was made in terms of Section 51 of the Employment Equity Act.
Yes.
And a point was raised that that's actually an incorrect usage. The correct section to use should be 1581G of the Labor Relations Act.
Yes.
Now, but in the course of your judgment, in paragraph 36 of that judgment, when dealing with that point raised by the respondents, you said that you are not able to dismiss or uphold that point and dismiss a case because the litigant relied on an incorrect statute.
Yes.
But then when you gave the order, you actually upheld that point, that the applicant relied on an incorrect statute. So I find that to be a bit contradictory.
Commissioner, if you can just bear with me. I definitely know that I did say that I'm not going to dismiss the review application simply because an incorrect provision of the Act has been relied upon. But what I said in the, if you can just bear with me to go to the order so I can see the contradiction that you are referring to.
At which page of the record is this?
page 102, paragraph 1,
Yes.
it says the review application ought to have been brought in terms of section 158(1)G of the Labour Relations Act and not section 51H of the Employment Equity Act. So, excuse me, where is the contradiction?
In paragraph 36 of the judgment.
36.
Because the respondents had actually argued that that review should not succeed because it's brought in terms of a wrong act, but also a wrong section.
Yes, so in paragraph 36, I'm basically saying the review ought to have been brought in terms of section 158(1)G of the Act, but it was in fact brought in terms of section 50 of the Employment Equity Act. So I said it doesn't matter, the fact that they've relied on an incorrect provision does not change the fact that this court still has powers to review rulings issued by the CCMA. So I'm not quite sure where the contradiction is, unless I'm still missing something.
Oh, okay. So as you understood it, the fact that the proceedings emanated from the CCMA
Yes.
actually gave you the jurisdiction to entertain the review, notwithstanding that the applicant made reference to a wrong section.
Yes, so I did say section 158(1)G is a provision that allows the Labour Court to review rulings. But in that matter, the review application had been brought in terms of section 51H of the Employment Equity Act, which does say if I recall, it's something to the effect that the court can also review decisions made in terms of the Employment Equity Act. But I was very specific to say where you are dealing with a section 10 claim, a discrimination claim in terms of the Employment Equity Act, that same provision tells us that you must process those disputes in terms of section 158(1)G of the Labour Relations Act, and that's what I did. So I said I'm not going to dismiss the review application based on a technicality, because whether you do it in terms of section 51H or section 158(1)G of the Labour Relations Act, the point is the Labour Court still has the jurisdiction to review rulings.
Thank you, Chief Justice. My second and last, if I may, and this one is very innocent.
I hope so.
If you are sitting as a Labour Court judge and you find that you do not have jurisdiction, do you dismiss the review or do you strike it off the roll?
Yes, thank you for that. I would strike it off the roll, but having said that, I do know that there's an LAC judgment that says sometimes judges dismiss the matter, but strictly speaking, it's not dismissing. You're striking the matter off the roll, except that in a case of jurisdiction, I don't know, striking the matter off the roll suggests that you can re-enroll it, but you can't re-enroll it if the court doesn't have jurisdiction. So, yeah.
Thank you, Chief Justice.
Commissioner Nkonyan?
Thank you, Chief Justice. Good morning, Ms. Gandidze.
Morning, Commissioner.
I am impressed by you having achieved LLB with cum laude in my alma mater in Fort Hare, as well as, of course, what you have already told us you have done. And again, I see that if you are successful, you may be a walking encyclopedia, as it were. We've got 24 years. Now, my question to you, which I need to preface in this fashion. In South Africa, we do have many foreign nationals, Chinese, for instance, that were convicted here in Gauteng, and for having flouted our laws. And there were also some people that were involved in a building in Western Cape that collapsed. Now, my question is, in the stint that you have been involved in labor matters, did you come across any matter involving foreign nationals? And if so, are you able to share with us your experience, and as well as how you would deal with this matter, because it is a matter of concern to all South Africans, of course, including yourself as a South African. So can you just give us some indication how, whether you had such experience? If you have not, perhaps in future you come across a case of that nature, what would be your decision along those lines? Thank you, TJ.
Yes. Thank you, Commissioner. I think the question you're asking me is related to the question that the other commissioner asked me about my activism work and whether that's likely to influence me when I write my judgments. And the answer that I gave then stands. But having said that, I'm not aware of any matter that I've worked on where there were foreign nationals involved. Maybe they were, but if the papers do not refer to the fact that they're foreign nationals, I have no way of knowing that they are foreign nationals. But what I did indicate in my questionnaire is back in the day, there was a discrimination matter that I was requested to assist with through the SASLO Pro Bono office involving foreign nationals. And obviously when I represent people, I represent everybody, whether you are a foreign national or you are a South African. And when I sit as a judge, it's the same story. Whether you are a South African or you are a foreign national, I'm just applying the law. That's what I do. I look at the facts and I apply the law to the facts.
Thank you, CJ.
Do the NEDLEC members have questions for the candidate? Yes, go ahead, sir.
Thank you, Chief Justice. And commissioners. Ms. Gandidze, one question, I mean, you were asked about conciliation and mediation.
Yes.
At NEDLEC, we've just agreed now in the amendment to the Labour Relations Act to put a provision that requires the Labour Code to involve itself in mediation and conciliation. Now, the question is, do you think that process can help in reducing the backlog in the Labour Code?
Definitely, Commissioner. Any dispute resolution system that does not involve litigation will definitely be of assistance to the parties themselves, because then you get an outcome sooner rather than later. But it will also assist in terms of the backlog that you spoke about. We have the backlog because there are litigants waiting to be heard. And if those matters can be processed through a system other than litigation, such as mediation, then it will definitely assist.
A second question, Chief Justice, is that we at NEDLEC agreed and published the amendment to the Code of Good Practice. I'm not sure what have you got aside of it? Do you think, and what's your view in the code, and do you think that it will assist in judges in the interpretation of the law in the areas that the code has unpacked further, the one that has just been published for public comment?
Commissioner, to be honest, I haven't looked at the code, so no, I'm not aware of what it says about mediation. So no, I will be guessing, which I won't do.
Any more questions from the network members? Yes.
Thank you, Chief Justice and Commissioners. Just to apologize first, I have been outside since 9 in the morning. I think I did greet the Chief Justice when she came from the VIP side. I was sitting in there. So I wanted to clarify that I have been outside.
So you did not keep us waiting?
Not at all. I did ask, and I was told there was an electoral court session that was going on earlier on, and I have a memo from the Secretariat that told me that it will start at 10:50, written by Teboho. So I have been sitting outside.
JSC proceedings are very fluid. You never know when you'll finish with a particular candidate. So if you are expected to be here on a particular day, you must set that day aside so that if you are needed at any time, you do not keep everyone here waiting. I do take the point that you were here at 9, but when the Secretariat looked for you, when it was your turn to come and interview these candidates for the Labour Court, you could not be found. That said, you are forgiven.
I have no questions for the candidate.
You may put your question.
Oh yeah, thank you very much, Chief Justice. My name is Mkoma Zitwala, representing Labour in Natlek. Well, my question, Mrs. Gandidze, is that our Labour Court is a critically important component of our judicial system. And its current functioning or dysfunctionality has a serious impact on the lives of thousands of workers who rely on the CCMA and the Labour Court for justice when they are mistreated and illegally dismissed by employers. And of course, the reports that we are having is that there is quite a huge number of backlogs of Labour Court cases that obviously have an impact on workers. May I ask, how do you think the situation can be improved in the Labour Court so that we deal with the backlogs that are there of cases? Thank you very much.
Yes. Thank you, Commissioner. I am aware that in the Labour Court, they have introduced a system where practicing attorneys are requested to assist during recess with mostly interlocutory applications, just to make sure that you get through the workload. But what I've also done personally, sitting as a judicial officer, is that sometimes a matter comes before you, and for whatever reason, the employer does not want it to go on. Maybe they are not ready to argue the matter. Maybe the heads of arguments are not on the file. And I say to them, no, I'm hearing the matter, even in the absence of the heads of arguments. You can file your heads of arguments 2-3 days later. I will consider them and I will take them into account before handing down judgment. That's my way of just making sure that, you postpone a matter or you remove a matter from the roll, but that matter is coming back to the roll. So we need to find a way to just make sure that when matters have been set down for hearing, they proceed, unless there is a very good reason why it cannot proceed. So personally, as a sitting judge, I've refused to postpone matters for reasons that I don't think are compelling. And as you say, at the back of my mind, I'm thinking about this employee. Whether they are going to be successful or not is a different story altogether, but everybody needs closure. So I want to hear the matter so that a judgment can be rendered and there is some sort of closure for the affected employee.
Okay, thank you. All right, Commissioner Baloyi, I'm so sorry. Yes, it's your turn.
Good morning, Ms. Gandidze.
Morning, Commissioner.
Yes, just to go back to the discussion with Commissioner Mangena about the jurisdiction point, and as I understood you, and please correct me if I'm wrong, you seem to either be non-committal about what you would do if you're confronted with a jurisdiction challenge, or you either non-committal or you're wrong when you say that you would strike the matter off. Did I understand you correctly, what your position is on this?
Okay, thank you for the opportunity. I've actually thought about it a little bit more after I gave the answer that I gave earlier on, and I think I want to revise my answer and say it depends on the issue. So if I'm saying the court doesn't have jurisdiction because the referral was made to court late, then I can strike the matter off the roll to give that party an opportunity to then file a condonation application. And once the condonation application has been decided, the matter is now properly before court, which can then determine it. So that's a jurisdiction issue. But sometimes you have a jurisdiction issue such as an unfair labor practice dispute has been referred to the labor court, which should be referred to the bargaining council or to the CCMA. There is no point in striking the matter off the roll. In that kind of a case, I would dismiss the matter so that the party knows that this door is closed. You need to go and knock on the doors of the CCMA or the bargaining council. So I guess my answer is it depends on the nature of the jurisdictional point that's being raised.
Yes. Thank you.
Thank you.
Thank you, CJ.
Commissioner Pillay.
Thank you, Chief Justice. Good afternoon. Good morning.
Good morning, Commissioner.
I just want to take you back to the Mugavazi matter.
Yes.
The SAA matter.
Yes.
And your finding on lis pendens.
Yes.
And if I've got the facts correct, in that case, NUMSA had referred a dispute of unfair dismissal based on the retrenchment.
Yes.
And they contended that the retrenchment was substantively unfair.
Yes.
Then Ms. Mugavazi came 2 months later and she referred a dispute of automatically unfair dismissal.
Yes, it's the main claim, and as I recall, I think there's also substantive and procedural unfairness in the alternative.
That's right. So her alternative claim was ordinary unfair dismissal. Her main claim was automatically unfair dismissal.
Yes.
And the reason that she referred an automatically unfair dismissal complaint is because she said that her selection for retrenchment was based on discriminatory grounds.
Yes.
And bearing in mind this factual matrix, and bearing in mind that in the NUMSA complaint, NUMSA sought reinstatement of all the retrenched employees. And in Ms. Mugavazi's complaint, she sought reinstatement, alternatively compensation.
Yes, I think so. Yes, that sounds right.
And in your view, she would be entitled to relief in both matters?
No. So what I said was the claim that NUMSA had referred to court. In that claim, the court will not decide the discrimination point unless NUMSA amends the papers. And at the time that I was hearing the points in limine, in fact, NUMSA's matter in the labor court had been dismissed, and the matter was now sitting with the LAC because NUMSA had not referred the matter to the CCMA for conciliation.
But both matters were proceeding on the same set of facts, essentially the same cause of action, because you're challenging the fairness of your dismissal, albeit on different grounds, and the same relief being sought in both matters.
Yes, you could say that, but one of the things that I picked up on in that matter, which I reflected somewhere in the judgment, is that the employer was obviously hopeful that I would uphold the point, in which case all these matters would then go away, because remember that with the first claim, the labor court had already thrown that matter out, and that's why NUMSA was now appealing to the labor appeal court. But what influenced my decision was the fact that the referral made by Ms. Mgavazi is in fact the referral that followed the correct procedure that should be followed in terms of the Labor Relations Act, which is to refer the matter for conciliation first, and if conciliation fails, to then have the Labor adjudicate the matter. NUMSA had jumped that first point, which is why the Labor Court had in fact thrown out the matter. So I decided the matter on the basis that if you want to raise the point in limine that there is a pending matter, that then it's in fact in respect of the referral made by NUMSA that the least pendants point applies, because NUMSA referred the matter to the Labor Court after Ms. Mgavazi had referred the matter to the CCMA for conciliation. So in fact, NUMSA's referral came afterwards. So I was trying to make the point that if you want to say there is a pending matter, you should be raising that point as it relates to NUMSA's claim, because they referred their matter after Ms. Mgavazi had referred the matter to the CCMA.
Your judgment records it differently. It records that NUMSA had made the referral first, and that Ms. Mgavazi, she comes second. Sorry, Mgavazi comes second. But also, I just want to check with you, if NUMSA has appealed to the LAC, do you not see that as a pending matter?
Okay, so when I say NUMSA, sorry, when you say the judgment says NUMSA referred the matter to the Labor Court first, yes, that is correct, but Ms. Mgavazi referred the dispute to the CCMA before NUMSA referred the matter to the Labor Court. So for me, that distinction is very important, because remember, as I said, you don't start at the Labor Court, you start at the CCMA. So if one party goes to the CCMA, which is the correct procedure, and another party skips that process and goes to the Labor Court directly, in my interpretation, you work with the matter that was first referred to the correct forum. So I accept that NUMSA's referral to the Labor Court was made first, but Ms. Mgavazi's referral to the CCMA for conciliation was made first. Then the other issue that you raised, that because the matter is at the Labor Appeal Court, my thinking was Ms. Mgavazi is seeking to pursue an automatically unfair dismissal claim in the alternative, substantively and procedurally unfair claim. And the discrimination matter is not even part of the matter that the LAC is being called upon to decide. So I took the view that she's well within her rights to decide which course of action she wants to pursue. And so I found that, there was no basis for the points in limine that had been raised.
Thank you, Chief Justice.
Thank you, Commissioner. Any further questions, colleagues? No. We've reached the end of your interview, Ms. Gandidze. Is there anything you'd like to raise with us before we excuse you?
No, CJ, I'm done. Thank you, commissioners.
Thank you for making yourself available. You may go.